So for those of you who don't know me, I'm Jason Hintersteiner. I run our field application engineering team at Ingenious Technologies, which is basically a fancy way of saying that I'm the lead system engineer at Ingenious. I've also done some sideline consulting work, and most of you who've seen me at these kinds of conferences in the past know me about getting up and talking about Wi-Fi in the small and medium business world. I'm not talking about that today. I'm going to talk about something completely different. I'm going to talk about expert witness testifying in Wi-Fi networks. So what is an expert witness? You are basically a hired gun. You're a witness in a court case, and you're brought in as an outside expert. You're a recognized professional and authority in a specific technical field, in our case, Wi-Fi. You're hopefully an outside objective observer, which means that you were not involved in the original project, and that you're kind of brought in after the fact as a quasi-neutral party to kind of figure out what happened and who's right and who's wrong. And hopefully you're a person that can speak with knowledge, authority, and truthfulness. Both sides in a case will typically supply their own expert witnesses. So when you're an expert witness in a case, you're on one side, and you will typically have a rival, one or more rivals, on the opposite side, because the other side will get their own expert witnesses to counter what you're trying to tell them. So what are the core issues that generate a court case in the first place? Typically it comes down to two things. The first is a breach of contract. Right? Typically that means that somebody didn't pay for something that they should have, and they probably didn't pay quite a lot of money for something that they should have. Failure to deploy to specifications, if there are specifications. Failure to follow legal and regulatory guidelines. And then failure of overall performance. The other thing that there needs to be in a court case is not just a breach of contract, but also damages. Right? It's not just a matter that a contract was breached, but that there were damages as a result. The damages could be financial. They could be property losses, such as, hey, you had a security system in place and it failed and then something got stolen, right? Or something got breached. Or it could even be, in extreme cases, loss of life. For example, if you have a medical monitoring system and the system failed and somebody died as a result, that could generate a court case. So what are usually the core problems that underlie a case that's brought about a Wi-Fi network? They tend to be the same kinds of things that we encounter when kind of troubleshooting any network. The first is bad documentation. Poorly defined requirements, poorly defined constraints, very poorly defined deliverables. The cases that I've been involved in, the contracts and the statements of work and the RFPs were written so badly that you could basically interpret them to mean anything you want them to mean. They had no requirements whatsoever. And very poor expectations of performance. If the end customer says, well, I want you to put Wi-Fi in this property and it should just work, well, what does that mean? We all in this room know that that's a very difficult question. And if you're just saying it should just work, that could mean pretty much whatever you want it to mean. And in courts, of course, and in cases, you're trying to get down to what are the actual facts. So if you have no facts and it's just a matter of expectations, this could be very difficult to unravel. Failure or improper expectations of the network performance and or the services that are provided, and a lack of technical expertise by one or often both parties. Very commonly in these types of cases, and I know there are a few people in the room like Keith and a few others who have done expert witness testifying in these types of cases. Right? Lack of expertise, often by both sides, is a big problem. So typically, right, both sides have some element of fault. Right? It's usually not one side's completely right and one side's completely wrong, because if that were the case, you probably wouldn't be getting lawyers involved. So what are the qualifications to be an expert witness in Wi-Fi? For those of you that do consulting work, or for those of you who may in the future find yourselves doing consulting work, this could be a very lucrative practice. You need to be a recognized leader and authority in wired and wireless networking. You should hopefully have a good educational background and good degrees to point to. More importantly, you should have certifications. CWNE is very, very useful in this regard, but you don't need a CWNE. When I first started doing this, I didn't have my CWNE. I did have some of the professional certs, but I didn't have my CWNE yet. Other respected certifications, such as CompTIA, and then if you're, for example, working on a Cisco network, having Cisco certifications would probably help. Previous experience as an expert witness is a big deal. The lawyers will always ask you, have you done this before? They prefer people who have done this before. So it's a little hard to kind of break into doing this when, because some case always has to be the first case. More importantly, even than education and certifications, is that you actually have demonstrated work experience, that you actually have practical knowledge over the issues that are directly applicable in the case. Hopefully you also have a reasonable breadth of knowledge and expertise surrounding the case, because Wi-Fi by itself is rarely enough, right? Wi-Fi doesn't work in a vacuum. It interacts with wired networks, right? It interacts with routers. It interacts with internet access. It interacts with clients, and so you need to know a little bit about all of these things and not strictly just, hey, this is how the access points work. Publications are also very, very helpful. So blogs, conference talks, lectures, teaching, right, any publications, any technical papers or books, those are all very, very helpful. By the way, you notice that the requirements for the qualifications are very similar to the requirements for going after your CWNA. So for those of you who are on that track, you're well on your way. So what do you do as an expert witness? The first thing that you wind up usually doing is a forensic analysis. And it's forensic because it's definitely after the fact, right? Some network was in place, something went wrong, parties decided that they were going to sue, and you're brought in as an expert witness after all of that happens. So the first thing you're going to do is review what were the requirements and what were the expectations. So were there RFPs, were there contracts, were there statements of work? You're going to determine the quality of the requirements, and you're going to determine if one or both sides over-constrained themselves. Many of you, I'm sure, have seen requirement documents and RFPs that will over-constrain the design. In one case that I've worked on in particular, the end customer told the WISP vendor, you shall put the APs in these locations. And that's one of the reasons why they had problems on the network, is because they didn't actually allow the WISP to specify where the APs were going to go. They were told where to put the APs. You're going to wind up at least doing a predictive model. Often, if it's after the fact, for example, if a wireless service provider was thrown off of the property and replaced with somebody else, there is no network to go analyze, right? But this isn't a pre-design, right? This is actually a post-design, right? The design was in, something about it didn't work, it was ripped out. Now you have to try to figure out, well, why didn't it work? Predictive modeling is often one of the only tools that you have to do that. If it is still in place, or even if it is replaced by another network, then doing a passive or an active site survey can also be useful. This, however, requires physical access to the site, obviously, which you may or may not have in various stages of this process. If the network is not deployed anymore, right, then doing a passive or active survey may not be of much value. If it is deployed, though, often you can typically, since it's a forensic analysis, you can often do a representative sample, which means I don't necessarily need to survey every single floor in a building. I could maybe survey 2 or 3 floors and get a kind of a picture of what's going on. The next step is usually the deposition, where you sit in a law office and you get grilled by the opposing attorney. Everything you say is recorded on public record. Your client and your attorney are generally in the room, but they're usually not allowed to intervene unless the opposing attorney goes over the line. And the deposition can easily last several hours, and in very complex cases can even go several days. The things that they will attack you on, the first thing they will attack you on is your credibility, right? They're going to review your academic and professional credentials. They're going to quiz, they may quiz your knowledge, but keep in mind they are not CWNEs who are interviewing you, so they wouldn't quiz you the way that Devin or Keith might quiz you. They're going to review anything that you have published, so any blogs, any publications, any social media, Twitter posts, stuff on LinkedIn, that's all public domain, that's all fair game. They're going to review your independence and objectiveness in the case, and your goal is to demonstrate that you are the expert that you claim to be. The second thing that they will attack if they can't fight your credentials is your conclusions. So they're going to drill down into your reports and your forensic analyses. They're going to attempt to poke holes in your analysis. They're going to attempt to divert attention away to unrelated or peripherally related topics that help the other side. And your goal, of course, is to communicate your conclusions that support your case, even if the other side is trying to avoid those topics. Finally, most cases settle, but occasionally you do actually wind up going to trial, because trials are expensive. So typically, if it's just a financial loss, most cases will settle. A trial is very similar to a deposition, but now you're in a courtroom, you're with a judge and potentially a jury, depending on the nature of the case. You need to anticipate what questions you will be asked, but a lot of the questions are the same as what you had before. I've got like 2 slides left. You usually can't introduce any new facts, so by the time you go to trial, you're kind of stuck with what you got. You need to review your own deposition, and you need to review the depositions of opposing expert witnesses. And things don't always go according to plan, so remember the old adage, even mistakes have to look like part of a brilliant plan. Tips for being successful in this: the opposing attorney is not your friend. They will try to trip you up. They will ask questions with double negatives, compound questions. They may be verbally abusive. In short, they may be like the old professional exams on the CWNP. So you got to expect that. Keep your answers factual or based on your professional opinion. And don't get rattled. Don't let them rattle you. Feel free to pause or to ask the lawyer to clarify, because they hate it if they have to back up and they lose their stream. Right? Don't let them make you lose your stream. Finally, don't volunteer information. Answer only what's asked. And as engineers who like to teach, this is really, really hard. It's much harder than it sounds, but you really just have to answer only what's asked. You really need to avoid technobabble, which we're all very guilty of in this room. Keep your answers understandable and reasonably non-technical. Watch out for inconsistencies. Remember, you're not unbiased. You're being employed by one side. And at trial, your audience is the judge and the jury, not the other lawyer that's actually asking you the questions. You have to face them, and you have to convince them of your expertise and your credibility. And with that, I'm a little over time, but thank you very much.